Hi, my name is Liza Zamd, and I'm an attorney in the Civil Rights Division of the Department of Justice in an office with a very long name, the Office of Special Counsel for Immigration-Related Unfair Employment Practices. But we already ran long in the prior presentation and will run even longer if I say the full name of my office every time I want to say it, so I just go by OSC. And has anybody heard of my office before? Has anybody ever called my office's hotline? Has anybody ever spoken to me? Liza. Okay. Hopefully, those of you who have called my office's hotline know what a great resource we can be, especially because of our interventions that I'll talk to you about in greater detail today. But as your colleagues in the prior session will likely be able to tell you, there's a lot of information for you to learn, or some that you might already know about. And if we go long, I'm actually going to keep on talking even into the lunch period because this is being recorded. But I really encourage you to ask me questions while we're going through this because I would rather answer them so that the information is relevant to you. So feel free to raise your hand, interrupt me, it's no problem. My office investigates and prosecutes national origin and citizenship status discrimination in employment. And as I mentioned, we're going to go through a ton of information today. But by far, the most important thing that you will get from today's presentation are these phone numbers right here, especially the worker hotline. Because my office has hotlines available for all employees or employers from Monday through Friday, 9 a.m. to 5 p.m. Eastern Time, where any person can call us in any language to ask us questions about their rights, or from the employer perspective, to ask us questions about their obligations under the law. And because calls can be anonymous, people don't have to fear that they're somehow going to be, tracked or that anything will happen as the result of the call. And the reason why this is so important is because, as we'll discuss, my office can do interventions on your behalf or on behalf of your clients where we call the employer at that moment to stop the problematic practice. So today we're going to talk about the history of OSC, and then we're going to go into the different kinds of discrimination. We're going to talk about how discrimination relates to the I-9 process, and then discuss hot topics like E-Verify and no-match issues. We'll talk about how my office investigates charges, and then the resources that are available to you and your clients. So OSC was created in 1986 with the passage of the Immigration Reform and Control Act. And that's the law that gave about 3 million undocumented workers a path towards citizenship. And as the result of this law, Congress also required employers for the first time to get information about a worker's identity or employment authorization, or I should say, and employment authorization. And they created the Form I-9 for that process. And they created fines for employers who knowingly hired undocumented workers. And I stress the term knowingly because that is the legal standard. If an employer happens to hire someone who did not have permission to work, but that person presented documents that looked valid and reasonably related to them, the employer hasn't violated any law. But Congress understood that even though that there was this knowing requirement, that employers might not want to hire people who looked or sounded foreign. So they created the anti-discrimination provision, which is what my office enforces. And what's interesting is that 4 years after the law was passed, the General Accountability Office came out with a report. And what they had done is they had sent surveys to millions of employers asking them, what did you do before November 6, 1986, and what are you doing now? And 19% of employers admitted that they now had discriminatory practices based on citizenship status or national origin. And so these were employers who in 1986 did not have these practices, but after the passage of the law did. And these are just the ones who admitted to it. And so Congress was right. There was a very large need for workers to have these protections for citizenship status and national origin discrimination. There are 4 things that are prohibited under the law that OSC enforces. The first is citizenship or immigration status discrimination. I'm going to use those 2 terms interchangeably. The second is national origin discrimination that you might be more familiar with because it's also covered under another law, Title VII of the Civil Rights Act of 1964. The third is document abuse, and this is by far the most prevalent type of discrimination that my office sees, and yet people don't know that it's illegal. And then the last is retaliation. Citizenship status is defined as treating workers differently because of their citizenship or immigration status in hiring, firing, and recruitment. And so what does that mean? That means that if an employer says, I'm going to pay all non-US citizens $5 less per hour, that's discrimination based on citizenship status, but it is not illegal because that is a term or condition of employment, and that is not covered under this law. But employers can't discriminate for hiring, firing, and recruitment, and we're going to talk about what that means in a minute. And all employers who have 4 employees or more are covered under this law. So all but the very smallest employers are covered. Now, there are situations where employers can discriminate based on citizenship status. And I'm not talking about terms or conditions here. I'm talking about hiring and firing. The first is, for example, with my job. For me to be an attorney at the Department of Justice, I do have to be a US citizen. And so if there is a government contract, regulation, executive order, or law that requires citizenship, well then that's okay. Another situation when you might have a citizenship status requirement is the obvious one if the person is not work authorized. Employers are required to say to someone who does not have permission to work in the United States, I can't hire you. Lastly, an employer is not required to hire all different kinds of citizenship statuses. They are not able to discriminate against US citizens, nationals, recent lawful permanent residents, asylees, and refugees. So it would be illegal for an employer to say, I only want to hire US citizens or permanent residents. Why? Because that discriminates against refugees, asylees, and nationals, so they can't do that. And so what we'll find out is these examples of citizenship status discrimination in hiring and firing are some things that you might have seen yourself. And so you had a question?
Yeah, the biggest problem we have is I-94 and the Social Security. It is on I-9, it doesn't mention only I-94, even if it says authorized to work.
So the question is about an I-94, and we are going to spend a ton of time on the I-9, and so I will pick up that question when we talk about the I-9. So what are examples of the citizenship status requirements that we see that could be illegal? First, we see often employers who say US citizen only. We had a case against 2 sheriff's offices, one in Colorado, where they were requiring US citizenship for their sheriffs. But there was no law, regulation, executive order, or government contract in Colorado that permitted them to exclude sheriffs to only US citizens. So that is illegal. In contrast, I think it's in Indiana, they do have a law that says that to be a sheriff, you have to be a US citizen. So they could have a policy that says US citizen only. But we also see the opposite. Sometimes we find that US citizens and US workers are the ones being discriminated against. And this can occur, for example, in the agricultural industry, where employers are preferring guest workers. Or this can occur in the IT industry, where employers are preferring people with visas, H-1B visas typically. And it doesn't matter. It doesn't matter whether you are a naturalized US citizen or whether you're born here. It doesn't matter whether you're a refugee, asylee, you're protected from citizenship status discrimination if you fall under one of those categories. And if you ever see a US citizen only hiring policy, please let my office know. Because what we do is we will contact the employer and we will say, justify to us why you have this policy. Now, some employers say, oh, well, this is the problem. I have a contract with the Department of Defense. And so the workers who work on that project have to be US citizens. Fine, that's ample justification if their contract actually says it. But why are they requiring the receptionist to be a US citizen? Why are they requiring workers on other contracts to be a US citizen? They can't do that. That would be illegal. And you had a question?
Yeah, the U.S. Army Corps of Engineers, they only hire U.S. citizens. That's in their website. Like if if you want to apply, you have to be U.S. citizen. When I was a student, they were recruiting in my college, and when I went there and I wanted to apply, but I told them that I'm not a citizen, they say you cannot apply.
And so that might be in the same way that for me to be a Department of Justice employee, I also had to be a U.S. citizen. There's a lot of federal jobs that are permitted to have a U.S. citizen-only hiring policy. And that's because there's a law, regulation, government contract, executive order, things like that that require it. But what I mean more are private companies, right? So for example, I had a case out of Maine where a Wendy's restaurant was requiring U.S. citizenship. And it was a chain. All the chains of Wendy's in that state were requiring it. And there's no law, regulation, executive order, government contract that says that to work at a fast food company, you have to be a U.S. citizen. And so that is illegal. And so what the situation that you describe, I would say still send it to us, because we'll call the Army Corps of Engineers. Well, they're the federal government, so likely we don't have jurisdiction over the federal government. But if there was a state agency that was requiring it, or a local agency that was requiring it, then let my office know, because you would lose nothing. We wouldn't say who it came from if you didn't want us to. We could just say that we received anonymous information telling us that there was a U.S. citizen requirement, and we wanted to know why. Now, national origin discrimination you might be more familiar with, because this is covered under another law as well, under the Civil Rights Act of 1964. So national origin discrimination is defined as treating workers differently because of their name, their accent, their country of origin, their ancestry, maybe if they're an native English speaker or not. These are all examples of national origin discrimination. Now, all work authorized people are protected from national origin discrimination. So when I told you before about citizenship status, all those exceptions, they don't apply to national origin discrimination. But the law can be broader depending on how many employees the employer has. And so if you see, OSC covers employers that have between 4 and 14 employees. And does anybody know why? Does anybody know what happens to those employers that have 15 or more employees? They're protected under the Civil Rights Act of 1964. And so, for example, with my office, we only cover hiring and firing and recruitment. So if an employer says that they're going to make all the Cambodians work the second shift, which is the worst shift, that's discrimination based on national origin, but that is a term or condition of employment. So it is not illegal if the employer has 14 or fewer employees. But Title VII is very broad, and it does cover terms or conditions of employment. So if that company has 15 employees, then it is illegal. And so it depends on the size of the employer when we're talking about national origin discrimination. But don't worry, if you file with my office and the employer has more than 15 employees, we will give the charge to the Equal Employment Opportunity Commission, and it will be considered filed timely. And so the worker won't lose out just because the charge was filed with my office instead of with the EEOC. So what are some examples of national origin discrimination? Well, we see that some employers only want to hire native English speakers. And I was going to speak at a conference in Georgia, and the night before I was at the hotel, and I see an advertisement on the TV for a maid service. And they said very proudly, all of our employees are native English speakers. And so I immediately wrote down the name, the channel, the time, because that is evidence of employment discrimination. Why? Because if you can require your workers to speak English, and I say if because it's not always allowed, you certainly can't say that they have to be native English speakers. I'm not a native English speaker, and yet my English is still pretty good. I'm able to do my job, and I'm able to do it without despite the fact that English was not my first language. And so, certainly, if there's ever a native English speaking requirement, please let my office know. Now, what about the English speaking requirement in general? It depends on business necessity. So there could be a restaurant, and this is a typical example, where the wait staff need to speak English because they need to change orders, explain, orders to the customers, and that makes sense. But the kitchen staff in the back, they likely don't need to speak English because they can, just based on a little bit of understanding, still be able to do their jobs. And so it would likely be illegal if an employer said, I want all of my workers to be able to speak English without actually looking at the jobs that they perform to see if English is needed. And so if you have a situation where an employer is saying English is required, please let my office know. And someone in the previous session had said, well, what about safety? Sometimes employers say, we need this based on safety. And okay, if it's for a nurse in an emergency room, yes, that person should speak English. If it's for a 911 operator, yes, that person should be able to speak English. But these general safety concerns, because, oh, if an asteroid crashes onto the restaurant and we need to tell the workers what to do, you can't just have these potentially very rare occurrences justify why someone needs to be a fluent English speaker. Yes?
But couldn't they just say, like, that they're not hiring them because they're not qualified?
Sure. It's true. And so if an employer is not explicitly stating why they're not hiring a worker, it makes it much more difficult. But if the worker says, wait, this is so odd. I have 5 years experience working in a kitchen, and they hired somebody with only 1 year experience. Maybe that's the reason why. And when you file a charge of employment discrimination, you don't have to attach to the back the letter from the employer saying, dear applicant, I am not hiring you because I am discriminating against you based on your national origin, right? Employers are more sophisticated than that. They often don't admit to their policies. When you're filing a charge, what you're saying is, I think that maybe I was discriminated against based on X, Y, or Z reason. And that's what our investigation is for. And then what we'll look is we'll see who was hired, who wasn't hired, who are the other applicants who have not been hired, who are the other people who have. And if the commonality between them is, oh, well, they're never hiring people who don't have good English skills, well, then that could be circumstantial evidence of discrimination. Yes?
So who determines what positions need English and what positions don't need English?
It's a very specific inquiry based on jobs, and the Equal Employment Opportunity Commission has a lot of information on their website based on this thing. And so you can't say, well, actually, I would feel very confident in saying every nurse who works in an emergency room needs to be able to speak English. I feel confident being able to say that. I don't know that I would be able to feel confident saying no restaurant worker ever who's in the kitchen ever needs to speak English. Maybe that's not the case, but it's all on a spectrum. And so the Equal Employment Opportunity Commission has great information on their website, and ultimately the worker can file a charge, and my agency or the EEOC, we would decide whether it's reasonable for the employer to make these requirements. So document abuse is the type of discrimination that is most problematic, that most folks don't even know that it's illegal, and I'm guessing that most of you have probably seen this in some form or another. And this is when an employer, for the purposes of I-9 or E-Verify, asks a worker for more or different documents, rejects valid documents, or specifies the documents that they want because of somebody's citizenship status or national origin. And I know what you're thinking. You're like, okay, what does that even mean? What that means is when the employer says, oh, you're a permanent resident? Well, then I need to see your green card. If they're not requiring proof of status from everyone, that is illegal. If they say, oh, you refugee, I don't want you showing me driver's licenses and a social security card. I want to see your EAD, your employment authorization document. Unless they're requiring US citizens to show their passports, that is illegal. And so we're going to go through today, later on, talking about the I-9 and talking about the I-94 and ways in which we see that employers abuse this issue. And one thing to note, all but the very smallest employers are covered. And so if there is a company that has 4 or more employees, they are not allowed to document abuse their workers. And so we're going to go through today, later on, talking about the I-9 and talking about the I-94 and ways in which we see that employers abuse this issue. And one thing to note, all but the very smallest employers are covered. And so if there is a company that has 4 or more employees, they are not allowed to document abuse their workers. So the most common example that we see is employers requiring List A documents. And when I say List A documents, what I'm referring to are documents from List A on the list of acceptable documents that's on the back of the I-9. And there's 3 lists, List A, List B, List C. And we're going to talk about them more in greater detail, but List A documents are US passports, passport cards, permanent resident cards, employment authorization documents, I-94s, I-551 stamps. They're basically immigration documents, or documents that show your status. Those are typically List A. And we see that employers are often asking non-US citizens for those documents, but letting US citizens choose whatever they want. And so I have a case in Georgia where a poultry company was doing exactly that. They said they wanted to make sure that the lawful permanent residents and the aliens authorized to work marked the right box. But they were accepting driver's licenses and social security cards from US citizens. But where on the social security card does it say that you're a citizen? Nowhere. Where on the driver's license does it say that you're a US citizen? Nowhere. So they're going to take the word of a US citizen and believe them that they marked the right box. But for the non-US citizens, they just want to make extra specially sure. And that is difference in treatment, and that is what is illegal. That second example on there is actually drawn from my real life. That's why it's there. My mother became a US citizen in 2008, and she got a job shortly thereafter. And for the first time, she marked on the I-9 that she was a US citizen. And she gave her employer a driver's license and social security card. And the employer said, oh, you have such a nice accent. Where are you from? And my mom told her that she's from Mexico, but that she just became a US citizen. And the employer said, oh, I'm sorry. Well, then I'm going to need to see your naturalization certificate or your passport. So my mom calls me that day. And at this point, I'm already an attorney. Well, no, this is not going to turn out like you think it will. I'm already an attorney, and I'm working at an immigrants' rights organization. And my mother calls me, and she says, so this is the problem. I have my naturalization certificate, but it says at the bottom, do not duplicate. And my mother is very rule-oriented, and she says, I know they're going to make a photocopy, and so I don't want to give it to them. And I said, oh my gosh, Mommy, like, why are you making waves? Just give them the document. If they make the photocopy, they're the ones who's violating the rule, not you. I had no idea that it was illegal. I had no idea that they weren't allowed to ask her for the proof of her status just because she was foreign born. And so don't think that just because you don't know about something that it couldn't potentially be problematic, because I'm embarrassed to say I was an immigrants' rights lawyer and I had no idea. And so if you're ever wondering whether something is suspicious or whether something is correct, call my office. Call me. Call the hotline. And we're going to be able to answer that for you. So before we talk about the I-9, I'm just going to discuss the last provision of the law that OSC enforces, and that's retaliation. And we were discussing before how national origin discrimination doesn't cover terms and conditions of employment under the law OSC enforces, even though it does under the Title VII, which is the law that EEOC enforces. This law does cover terms or conditions of employment. This law is very broad. And what this law says, this part of the law, is that an employer cannot take any action against a worker because the worker participated in an OSC investigation, because the worker was trying to assert their rights or assert the rights of others. Employers cannot retaliate, cannot take negative action just because they're mad that a worker has contacted OSC. And if you notice, this covers all employers who have at least 3 employees. So again, all but the very smallest employers are covered. So one example of retaliation is of a case that I had out of New Jersey, where there was a worker who worked at an IT company. She was a recruiter. And her employer came to her one day and said, listen, I don't want you giving me applications for US citizens and lawful permanent residents. I'd like for you to just focus on H-1B and OPT. OPT is optional practical training, which is a status that foreign students get after they've graduated and they can stay here and work for a while. And the woman, she knew nothing about the law, but she said, I feel like it's wrong that just because someone's a US worker, if they're qualified, that I'm not able to give you their application. And so they fired her. So even though she was protecting the rights of a hypothetical worker, she was still protected from retaliation. And she got $22,000 in front pay and back pay. Now, we had another situation of a poor worker out of Georgia who was working at a carpet factory. And he had been told when he was hired, he was sitting across from an HR person. So it was a line of HR people and a line of workers. So there were workers left and right of him and HR people across from him. And when he filled out the I-9, he marked US citizen. And they said, okay, let me see your green card. And the man didn't speak English, but he brought his driver's license and social security card out, and he said in Spanish to the HR person who did speak Spanish, I'm not a permanent resident, I'm a US citizen, here are my documents. And she said, whoa, 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 whoa. If you're a US citizen, why don't you speak English? And he said, well, actually, because I'm 65, and so when I took my naturalization exam, I was able to get it translated, because they let that happen for older workers. And she said, well, okay, if you're a US citizen, well, then I need to see your passport or your naturalization certificate. He said, that's fine, I'll bring it tomorrow. And she said, no, I'm gonna need it now. And he said, wait a minute. You're hiring all these white people and black people, literally who are sitting next to me, with driver's licenses and social security cards. And you're not hiring me because you think that I'm not a US citizen? That's unfair, I know what my rights are. And so they fired him. And on his application, they wrote, hired until he gave Maricela a hard time. And so he had been document abused in 2 different ways, right? Actually 3. They specified the documents they wanted from him, they rejected his valid documents, and they asked him for more and different documents. And then after that, they retaliate against him because he's trying to assert his rights. And so I have some people say to me, well, wait a minute, what if he had been really belligerent? And so, okay, let's say he had taken the chair and he had smashed it over the head of the HR person. Call the police, fire him, like get him escorted out from security? Absolutely, that's not retaliation. That's you making sure that your workforce is secure. But all this man did is express his frustration, which clearly he was right in doing because he was being discriminated against. And so you just have to be reasonable. And so if he had done some very severe things, then of course he could be fired. But giving someone a hard time because they're being discriminated against is not unreasonable. And so that's another example of retaliation. And just to be clear, retaliation in those 2 examples were about firing. It didn't have to be about firing. If they had said, oh, you know, Mr. Smith, I'm not going to give you that position that you wanted because you're giving me a hard time. That's retaliation. Or I was going to pay you $5 more, but now that you've given me this hard time, I'm going to give you, you know, $5 less. That is also term or condition, but that is also covered. So now the Form I-9. This is, you know, this is the main action, and this is where I'm sure the vast majority of your questions are going to come from. The Form I-9 is 2 pages. And are there folks here who have seen the I-9 before? Raise your hand. Okay, so most of you, great. The purpose of the I-9 is to get 2 pieces of information from the worker. Proof of their identity and proof that they have permission to work in the United States. It is not to prove their citizenship status. And I will say that one more time. The I-9 is not there for the employer to get proof that they marked the right box. Now, the I-9 should only be filled out after offer and acceptance of employment. Why? Because you should not be telling your employer ahead of time what your citizenship status is, in the same way that it would be problematic if an employer asked you, are you pregnant? What's your religion, right? These are all things that are totally irrelevant, that should not be asked at the application stage. And so with the exception of temp companies, we really encourage you to call my office if you see an I-9 in an application packet, because these things should not be asked about until offer and acceptance of employment.
If they separate in the hiring packet that says that the paperwork is clearly for after acceptance, is that still technically wrong, or is that technically okay?
Well, you know, employers are allowed in other circumstances. For example, you might have filled out jobs before that ask you what your racial identity is or what your sex is, and that's because the EEOC requires large employers to keep those statistics, but they're supposed to be kept separate. So if it's true that an I-9 is being kept separate, then my office's concerns are much less. And so, but you know, it's not best practice to do it. And so I would want to have a broader conversation with the employer, the employer's attorney, about what in fact is happening with that I-9 and why. Because the I-9 is only for employees, right? And so if you're filling it out, you should be an employee. But if you haven't been hired, you're not an employee. And so that's why it could be problematic.
Why temp agencies?
So temp agencies are allowed to fill out the I-9 because they want to put people in the pool of available workers so that they can assign them to a job. And so they're allowed to fill out the I-9 with the workers beforehand so that the workers can just start any position that they want. Yes?
If they do the whole like application process all at once, but they've already gotten the job, it's not a big deal if it's in the packet then.
Exactly, because then they've already accepted the job. And so then even though they're calling it an application, they're, have already been accepted for their job. Exactly. Yes?
So if somebody marked like he's a U.S. citizen, he needs to also provide proof he's a U.S. citizen?
No, the opposite of that. No one needs to provide proof of their citizenship status for the I-9. So now, for me to get a job at the Department of Justice, I had to prove that I was a citizen because that was a requirement, right? But for I-9 purposes, no one ever needs to prove their status, and it's illegal for an employer to make some people prove their status and not others. So the example that I gave of my mom, right? She wanted to show a driver's license and social security card. And only because she had an accent and she told her employer that she was foreign born, did they make her prove her status. Driver's licenses and social security cards are valid I-9 documents. They don't say anything about your status. And so it's not allowed for an employer to say, I want to make only some employees choose their status. If the employer is doing it to everyone, it's a violation of I-9 rules. But if they're saying, US citizens, I want you to show me your passports, your naturalization certificates, or your birth certificates. Non-citizens, I want you to show me your immigration documents. You're mistreating all the workers the same, so there's no discrimination.
So like basically you're saying like if, let's say I went to interview and they ask me question in the interview, are you authorized to work in the United States? And I say yes.
Mm-hmm.
And they tell me, show me the document, and I show them my passport or like my passport card. And they go and make a copy of it. Is that okay?
Yeah, absolutely. Employers are allowed to make photocopies of documents if they want. No, because you chose. And that's what the law requires, for the worker to choose. If the worker wants to choose to show their permanent resident card, sure, why not?
Yeah, but they asked me with that, and then I give it to them.
But they said, in your example, they said, are you authorized to work in the United States? That's a good question. Are you a US citizen, yes or no? That's a bad question, right? So are you authorized to work in the United States? Great. And then when they get to section 2, they say, okay, now prove to me your identity and work authorization, and you choose to show your passport. That's how it should go. But if you're wanting to show your college ID and your asylum stamp on your I-94, and they say, no, I want to see your EAD, that would be very problematic because they are rejecting the documents that you want to show, even though they're valid documents and they're documents that you're allowed to show. Yes?
I have a question about EID. If somebody was hired by a company and they provided EID, after it's expired, they ask them to
Show
renew
another
it.
document. Yeah.
And at that time, they applied for their green card, but they didn't get it yet.
So we're going to talk about that in a moment when we talk about re-verification. But that's an excellent question, so don't let me forget. So now, Section 1 of the I-9. So you're talking about Section 3, so you're only 2 sections ahead of time. Section 1 of the I-9, that's what the worker fills out. And if you want, or if the worker wants, somebody can fill it out on their behalf and just fill out the preparer translator. That's fine. Anyone can fill it out on behalf of the worker if they don't feel comfortable reading or writing English. And the worker has to put in their name, their address, their birth date. Social security number is optional unless the employer uses E-Verify. So if they want to leave it blank, they can. Email address and phone number are also optional, but we encourage workers to put it in there because if we're investigating an employer and we have questions about what their hiring practices are, we can call the workers if we see their email address or their phone number, or we can contact them if we see their email address and their phone number up there. So the worker fills out everything, and if they're a lawful permanent resident or alien authorized to work, they have to put in their alien number. Aliens authorized to work also get to put in their I-94 number if they don't have an alien number. And this is important because sometimes employers say, oh, I need to see your green card. Not for Section 2. I just want to make sure that you wrote your alien number correctly. And that is not allowed because the worker is who signed Section 1 saying that the information is correct to the best of their knowledge. So for example, if the worker accidentally marks their alien number wrong, if they forget a digit or they swap out a digit, If they're not purposefully doing it, then they've done nothing wrong, right? You're just signing that you're doing it to the best of your knowledge. And employers can't say that they want proof of these things. Now, if the employer is saying everybody needs to provide a social security card, right? Because they want to check the social security number. They're mistreating everybody the same. Not a violation of the law OSC enforces, but it might be a violation based on national origin under Title VII of the Civil Rights Act, because that covers not just difference in treatment, but difference in impact. And so if, for example, a police department has a rule saying that you must be 5'10" to work at the police department, that's a facially neutral policy. It's applied to everyone, women and men, doesn't matter. But it has an impact against women, right? Women tend to be shorter than men. There's also some races and national origins that tend to be shorter than others. And so saying that you need to be 5'10" to work for a police department could have a disparate impact based on sex, based on race, based on color. And so that could be illegal under the law the EEOC enforces, under Title VII. And so we say to employers, it is not best practice to have that social security number requirement, also because you folks might not know this, SSA will only give you 10 cards in your lifetime. And so if you lose that 10th card, they will not give you the 11th. And you think, wow, 10 cards, that's a lot of cards to lose. But you think about it, right now you have to get social security cards for your children once, when they're born. So if you lose a few of your kids' cards, and then they have some heady days in their 20s, and they lose some of their own cards, and then all of a sudden the employer isn't going to be able to hire a worker because the worker didn't have a social security card. Social security number requirements are something different. When the employer says, I require the number, we'll talk about that when we talk about refugee issues. But just so you know, not everything is required on the I-9. What we see for the biggest problem is employers requiring an expiration date. And if you look on the I-9, the first 3 boxes, U.S. citizen, national, and lawful permanent resident, those are specific immigration statuses, right? Those are particular immigration statuses that each have their own box. The alien authorized to work is everyone else. It's asylees, asylee applicants, refugees, H-1B, OPT, TPS, like the alphabet soup of everybody else, right? And so most people who mark alien authorized to work have to keep on asking immigration for permission to live and work in the United States. But who doesn't? Refugees and asylees don't. They can get an EAD if they want, but they're not required to have one. And when they're getting the EAD, they're not asking the government, hey government, can I please work here? They're just asking for the document, for like a travel document, in the same way that when I get my passport, it's not giving me permission to work, I just want to have this identification document. And so it's problematic when employers require the expiration date in Section 1, because even though their EAD may expire, their permission to work doesn't expire. And so that's why they should put NA. And USCIS did a wonderful thing. With this new I-9, they put some aliens may write NA in this field. And yet employers, they're blind to it. They see the NA that the worker has put and they say, no, I need an expiration date. So just train your clients that they should say to the employer, no, look at the next line, just like 1 inch over. It says some aliens may write NA and I am one of those aliens. Now, Section 2 is where we get into some issues as well. So we've talked about List A documents, List B, List C. What do those mean? List A documents are documents that show both identity and work authorization. So the passport, the permanent resident card, the work permit, those show both your identity and that you have permission to work. List B documents only show identity, and List C documents only show that you have permission to work. And the reason why you need the B with the C is because otherwise I could just take the social security card of any woman and say, hi, I'm Susie Smith, give me a job. But you need the identity document to go with it to show that you really am Susie Smith, and I'm not Susie Smith, so I wouldn't be able to get a job because the description of me or the photo on the card wouldn't be the same. And so the employer must fill out Section 2 within 3 days of hire, but 3 days is actually 4 days. And so what that means is the first day doesn't count. So if I'm hired on a Monday, that doesn't count. The employer gets all day Tuesday, all day Wednesday, and by close of business Thursday, I have to show them my I-9 documents. Now, some employers, they say, no, I want all the documents on the first day of work. It's not best practice. It's not correct under the rules. But if they're doing it to everybody, what does that mean? It's not discrimination. And so it wouldn't be discriminatory treatment for an employer to say that every person has to show me their documents on the first day. But what we see is we see that employers are requiring List A documents from those non-US citizens because they want extra special proof that that person has permission to work. And that's what you're not allowed to do. Now we see that there's also some issues with receipts. The I-94, which you, I think, had asked about. The I-94 for a refugee is a document valid for 90 days from the date they give it to the employer. That's the rule for any receipt. So for example, I lost my Maryland driver's license, and my receipt said that I could drive for my lost document for 45 days. Let's say on day 50, I still hadn't gotten my license. It doesn't matter. I can still use that receipt for 90 additional days from the date that I start work. Now, I can't drive in Maryland with that receipt, right? That won't fly because the receipt's only valid for driving for 45 days. But federal law says any receipt is valid for a lost, damaged, or stolen document for 90 days. The exception would be, let's say I lost my EAD, and my EAD was going to expire 60 days from now. My receipt can't go beyond those 60 days. So that would be an example. But for I-94s, that's not an issue. And for I-94s, at the end of the 90 days, the worker shows either a List A or B and C documents. The worker gets to choose. For asylees, as I mentioned before, that stamp, I-asylum stamp on the I-94, that's a valid List C document, valid indefinitely, never expires. So if someone shows an ID, an asylee stamp with the, on the I-94, they don't ever have to show other documents again.
But it doesn't say on I-9 form saying that you need this and this plus or this one.
The I-9 form does say it, right? So the I-9 form says you need either a List A or a B with a C.
It says with the passport.
Oh, okay. So I see what you're saying. You're saying that on the list of acceptable documents, it says I-94 with a passport. It's a wonderful question. Yes, because for folks who are not asylees or refugees, their I-94 or permanent residents, their I-94 typically has to be accompanied with the passport. But there is another issue, which is the receipt rule. And so although it's not on the list of acceptable documents, they do say in the I-9 instructions that some receipts are valid. And so in that situation, if the employer looks and says, I don't see the I-94 on here, then you would have them call my hotline, or they can look on USCIS's website. They have that information there as well, because we would let them know, no, that is a valid document. But that's a good point, that it's not explicitly there. For example, neither are naturalization certificates. Naturalization certificates used to be a List A document. They were taken off. Now they're a List C document, but they're not explicitly on the list of acceptable documents. They're under C number 8. C8 is any employment authorization document issued by the Department of Homeland Security. Some employers think that that means the I-766. They think it means the EAD. That is not what it means. The EAD is a List A document. But a letter from immigration saying that somebody has work authorization, like the I-797, sometimes they say that, that is a valid List C document. That with a state ID, school ID, that's enough for the I-9. And so you could just let us know, or you could have the employer call us if they have any questions. Yes, behind you.
Sure. So if you give the employer your I-94, in 90 days your social security card hasn't arrived, but you've applied for it, the letter that says that you've applied, does that cover it?
No, it's the, you know, if you haven't received your social security card in that period of time, then you can try to make an InfoPass appointment, get another I-94. I mean, actually the ability to do that is a little bit in question. If you have your EAD, that would work. But If you don't have I-9 documents and the 90 days have passed, then your employer is actually required to take you off payroll.
There is a clear instruction on I-94 for the employers very to understand it and to do it. So is there any additional things that you can do on the I-9, adding refugees and asylees, non-EAD or something like that?
Well, one thing, so the I-9 belongs to USCIS, right? It's not a Department of Justice document, it's a USCIS document. But one thing that they heard from refugee and asylee advocates is they didn't want, for example, a box that said refugee or asylee, because these are people who have fled from their country because of persecution. And I once had a client when I was working in my prior job who was a refugee who saw his tormentor, the guy who had burned cigarettes into his arm on the street. And he didn't want people, because you never know, you come to this country and there are people from your country who are on the other side of things, right? And so you never want to necessarily give away the fact that you were an asylee or refugee. Some people don't care, other people, they feel very strongly about that. And so there is a understanding of the fact that people might not want to mark a box that says they're asylee or refugee. But there is my office's hotline, and there is more information on USCIS. They have a website called I-9 Central. And so that website has a ton of information on the I-9. And sometimes what happens is an employer will call us or an advocate will call us. And if there's not a frequently asked question, or if there's guidance that might be a little confusing, we'll let USCIS know, and they're really great about updating their website, adding things, and so let us know if there's something that you think would be helpful to you or helpful for employers. But ultimately, there's that employer hotline, right? And so they can call us anonymously. They have no excuses as to why they can't get information that would help them fill out the I-9 correctly.
I have a question.
Yes?
Sometimes employer, they will not verify the I-9 for the clients. So they will tell clients, this is the form, call and verify, and give me the code that you get from the authorization. So I don't know, but we have faced that problem, that they will not identify that they will not trust. I was trying to identify I-9 that I was right to work in the state, but I cannot try to solve, and this is a form and fill it and bring it. I don't know if that is eligible.
So you're saying that your client had presented the I-94 and the employer accepted it, but wanted your client to call someone else to verify the number?
Yes, that is. Sometimes they will give the social security, that's the number to verify that they are eligible to work in the United States. So he says I was trying my best to verify that they are eligible to work in the United States.
That's going too far. Unless the employer is doing this for every worker, they can't just say some workers, because of the documents that they're presenting, have to go through these extra steps. The document itself is what shows that they have permission to work. If the employer has problems with that, well, then they tell Congress, because there's a law that specifically states that these documents are valid. And so it's not the employer's choice to say, well, this document I like less, and so therefore I'm going to make people try to prove it in some way. So if that happens again, please let my office know, because these workers should not be having to jump through extra hoops just because they happen to have documents the employer is less familiar with. Yes?
I have kind of a specific question, but if your client can provide the right documents, but on the two documents, the name is a little bit different.
Mm-hmm.
We are in Chicago, we send a lot of our clients to O'Hare airports, and we'll have clients who are rejected.
Yes.
Or security clearance issued because on their social security number they have
One,
5 names.
right.
PAD or state ID, they've shortened it down. It's on initials. Is that legal or illegal?
So TSA has their own requirements for airports, and we have been successful in calling the airports, and because it's not the employer, it's not the Subway restaurant in the terminal that's rejecting it. They're saying no, it's later on in the process, right? It's like for the security background, for the threat assessment, and we have had success in calling TSA and asking them. It's not 100%. But especially this is true because the Social Security card allows more letters than, for example, passports, EADs, LPR cards. So you can put your 37 names on the Social Security card, but you can only put 5 of them on the passport, on the permanent resident card, whatever else. And so there is a frequently asked question on the back of the Handbook for Employers. Have you folks ever seen the Handbook for Employers, the M274, M like Mary dash 274? Okay, for those of you who haven't seen it, it might revolutionize your lives. This is a document that immigration puts out that describes the I-9 in great detail. And at the end, they have frequently asked questions. And one of the frequently asked questions is, a employee said that they recently got married, and so one document has one last name and another document has another. And then what the employer is told to do is basically get information that would make them understand what links those two documents, but that they can be acceptable for the I-9. So in your situation, it's not even different last names, it's just fewer names, right? And so, or exactly. And so employers are often more sympathetic once they read that frequently asked question, because they're like, oh, well, if I can hire a worker who has Jane Smith on one document and Jane Johnson on another, well, then certainly I can hire a worker who just has some initial difference. But for the security threat assessment, for badging, that's on the TSA end. And so we would try to make a phone call and see if we could help in that way. Well, if they're doing it for all workers, so if the guy who is, daughter or son of the American Revolution, right, his family can be traced back to the Mayflower, if that guy can't have his initials put in on some documents, but other people can, then that's a problem. But, if they're being treated equally. The thing about the law OSC enforces is it's not necessarily only against employers. The law says a person or entity. So it's very broad. But for federal government, we can't sue the federal government, and so TSA is part of the federal government, but we can make friendly phone calls. So, yes?
So I wanted to know if I'm reading the second bullet point correctly. So individuals photograph of the winner, so that's essentially a document.
You're talking about the I-94 with the I-551 stamp? That's for permanent residence. So the I-551 is the code. So in the same way that I-766 is the code for employment authorization document, I-551 is code for permanent residence. And so that stamp is valid for a year, and then you show either a list A or C at the end. Because we are now getting to Section 3. So Section 3 is a section that there's a lot of problems with, and we see that employers are doing it wrong all the time. If somebody does not have permanent permission to work, or if they showed a document that requires re-verification, then the employer does have to go back to the worker and say, okay, I need to get new documents from you. But there are certain guidelines. Number one, US citizens and nationals should never be re-verified. Number two, List B documents, the identity documents, should never be re-verified. Number three, permanent resident cards should never be re-verified. Even the 2-year conditional cards, it doesn't matter. And so that's why we encourage refugees and asylees to put in the unrestricted Social Security cards as the List C, or their asylum stamp if they're an asylee, and then an identity document if they're a List B, for their List B, because if they show their EAD, the employer has to re-verify them. Even though they put NA in Section 1. The employer has to re-verify them if they show their EAD. And some people say, well, listen, this is my problem. My client has his EAD and his unrestricted Social Security card, but he doesn't have a List B document. What does he do? And this is what we say. The worker should put the EAD down for Section 2. The employer fills it out. And then the worker should say, okay, I want you to fill out Section 3 right now with my unrestricted Social Security card, and the employer never has to show, the worker never has to show any documents again. And it's important for the employer to know that A or C is valid because they get into a lot of trouble. So for example, my office had a case against Hilton Hotels because an asylee, when he was hired, he had his EAD, which is what he showed. He had a restricted Social Security card. He hadn't yet gone to SSA to get the new card. But by the time his EAD expired, he did have the unrestricted card. And so he gave it to his employer, and they said, no. You showed me a List A document to begin with, so I want to see another List A document. And they fired him. 4 months later, he found out about my office, and he called the hotline. I was randomly working that day. So I called Hilton, and I got him back to work. But they wouldn't give him any back pay. And so I said to the worker, You can leave it as it is, or if you want to try to get back pay, you can get back pay for the time that you missed by filing a charge. So he filed a charge. I investigated it, and yes, it was very clear that he had his unrestricted Social Security card that he wanted to show. They said no, and he got $12,600 in back pay. And so this is a situation where I wasn't fully successful on the hotline, but it shows that even if you call the hotline, you always have the option to file a charge. And in fact, we had a call where a worker called the hotline, and I was able to get him hired immediately. And he spoke to HR after this happened. And HR said, you know, it's such a shame that I didn't know about OSC before, because I've fired a lot of workers because of this same issue. And so the worker filed a charge with my office. He knew he would get nothing out of it. He didn't lose, well, he lost work, but he had been given back pay and he got his job back. That's the most he could be getting. But he wanted us to go find the other workers. And so the other situation can be a situation where something's happening with one of your clients and they don't want to tell their employer what's going on. Still tell us, because I have opened up several independent investigations based on phone calls that I've received from communities, from immigration attorneys, where they said, this is what happened to my client, but they don't want to get involved, but they want to, number one, prevent this from happening to other workers, and number two, get back pay for those workers who it might have already happened to. And so we can open up investigations without worker requirements. And so no worker has to file a charge. But we can't fix it if we don't know about it. And so that's where you come in. So now there are some special issues. I don't know if folks here deal with temporary protective status. Are there any advocates here who deal with TPS? Okay, so a few of you. So TPS is a status that's given to some workers because there's conditions in their home countries that are bad, and so they can't be taken back or deported back to those countries. So the most recent TPS was granted to the countries who are facing Ebola difficulties. Before that, Syria because of the civil war. Before that, Haiti because of the earthquake. El Salvador, Nicaragua, Honduras, Kosovo. All these countries have received TPS. And if there's a lot of people who have TPS from a particular country, it's a little bit harder for USCIS to print out their documents because all the documents expire on the same day. So for El Salvador, every person with TPS from El Salvador has an EAD that expires either on March 9th or September 9th, depending on the year. For Haiti, it's either January 22nd or July 22nd, depending on the year. And so what will happen is that USCIS will put a notice in the Federal Register that extends the EAD for 6 months. But the worker doesn't get anything that says their name on it and that says the EAD has been extended. So from the perspective of the employer, a worker comes to them and says, hi, here's my work permit. I know it looks expired, but it's been automatically extended. And the employer says, no way. And then they reject the document. Or if the person's already there, they'll fire the worker. But that's actually the rejection of a valid document because the document has been automatically extended. And so if you ever have these types of issues, please let my office know because these are very easy phone calls for us to make because the employers want to hire the worker, right? Or the worker's already working there. And so all we do is we show them the information off of USCIS's website. And it's a little bit frustrating that the employer isn't even taking a moment to Google TPS and then the country to see all the information that's out there. But they're very easy phone calls for us to make. Yes?
This person was on TPS and it is expiring next month. But he got another paper saying that he had been hurt, somebody hurted him and he got extension. Some kind of different EAD.
Somebody what?
Somebody hurted him, somebody beat him, tortured him.
Oh, because I see. You can switch your status, of course, and so it used to be a little bit more difficult. For example, if you had TPS and you married a US citizen and you wanted to adjust to be a permanent resident, you used to have to leave the country, and then in order to adjust, you would have to come back. And a lot of people, they can't do that. They don't want to do that. Now it's a little bit easier to be able to adjust out of TPS. And so I don't know what happened in that situation, but either way, a worker, if they have a EAD that has an A12 or C19 category code that expires on a particular day and it's been extended by immigration, it doesn't matter if they're in the process of adjusting to something else. But you can always call the hotline or the employer can call the hotline if it's a more complicated issue. We also see that employers sometimes don't accept prior versions of documents. And so the permanent resident cards, for example, in the 1980s, they don't have an expiration date. Why? Because permanent residents are permanently work authorized, right? And so there was no expiration date on those cards. But because of fraud issues, they then started putting expiration dates on the documents. But employers say, wait a minute, this card is 20 years old. It was issued in 1980. I'm not going to accept it. It's still a valid document, and so the employer should still be accepting it. We also see problems with employers not realizing that the Social Security card has changed. It looks different than it does now. And so if you ever have a situation where the employer is rejecting a document that's valid, call my office. We're happy to make a phone call. So asylees and refugees, we've spoken about these in some measure. They are indefinitely work authorized. That means that they don't have to keep on asking permission to work. Therefore, they get unrestricted Social Security cards, which are the cards that we really encourage employers or really encourage workers to present. They should only be run through E-Verify if there's an E-Verify employer after they receive their Social Security number. So we discussed before, what about workers who don't have a Social Security number? Well, as I mentioned, on the I-9, it's optional. They're not required to put it in. Some employers say that they want it from everyone, and as you know by now, if they're doing it to everyone, it's not illegal. But for this situation, there's a ton of guidance. So for example, either publication 15 or 51 from the IRS, it tells you how to run payroll without a Social Security number. You put all zeros into payroll. That is how you do it. It also says what to do in E-Verify if someone doesn't have a Social Security number. The answer is you put the I-9 to the side and you don't run E-Verify until the worker gives you the number. And so if you have any situations where employers are giving you a hard time because your refugee has not yet received their Social Security number, give my office a call, because these are calls that we make all the time. So the I-94, finally getting to what has been involved with a lot of questions. As you know, the old I-94 was a paper document, right? Sometimes the picture was stapled to it, sometimes it wasn't. All refugees will now get, as far as we understand, the new I-94, which they print out online. And so this is good news. This is ultimately good news because for the old I-94, you needed to make an InfoPass appointment in order to get a new one, right? And you had to wait a couple weeks, and some immigration offices weren't really giving them out. For the new I-94, you can just print it off the website. The problem that we see is that the new I-94 is not going to have a refugee stamp on it, but it is still a valid document. There's information on USCIS's website about it, and people can call my office if they have any questions. But both documents are still valid. So just because you have an old I-94 doesn't mean it isn't valid anymore. But moving forward, they're all going to be the new I-94s. Now, E-Verify is a program that we've seen some issues, especially for folks who are asylees and refugees. And do any of you come from states that use E-Verify, where it's either required or a large percentage of the employers use it? Okay, so there's quite a few of you, so I'll go into some detail. So what E-Verify is a database that takes the information from the I-9 and it checks the Department of Homeland Security and the Social Security Administration and even some DMVs. There's not all states, but I think it's now up to 8 states the information from the DMV is also put into E-Verify. And what it does is it's checking to see whether the person's information matches the records. And there are situations where the information will not match. Situation number 1, which is by far the most common, 99%. The HR person puts the information in wrong. A 1 looks like a 7, or people from other countries, their date convention is different, right? First they put the day, then the month, then the year, so their birth date might be transposed. Whatever it might be, HR person puts the information in wrong. Vast majority of TNCs are caused by that. Second reason, there's an error in a government database. And so for example, when my sister became a US citizen, she didn't go to SSA to let them know that she was no longer a permanent resident. A lot of people don't want to do it because they're like, oh, I don't want to have to wait in line. Why am I going to do this? Well, a problem can be that if DHS knows that you're a citizen and SSA thinks that you're still a permanent resident, that information doesn't match. A third reason can be the worker's undocumented. They created a social security number or a fake name or whatever, and the information doesn't coincide. So we're going to deal with the first two issues, the mistake from the HR person and the mistake in the databases. So for the HR person, what they're supposed to do if they get a tentative non-confirmation is they're supposed to look over their work and compare it to the I-9. And the vast majority of tentative non-confirmations are able to be resolved that way. They say, oh, you know what? Put in the wrong digit, or I should put in both last names, or only one of the last names, or whatever combination that it might be. But if the worker still gets the TNC, if the HR person still receives the TNC, then the HR person is required to print out the document and give it to the worker. And the worker can look it over and see and make sure that everything is correct. And if the worker wants, the worker gets to contest the TNC. The employer can't persuade them to just leave the job. They can't strong arm them into doing anything. The worker gets to choose. And when the worker decides to contest the TNC, what that means is that the employer has to print out a notice, and the worker either has to call the Department of Homeland Security or go to the Social Security Administration, depending on where the mistake in the database might be. And so the worker will not know which government agency has the mistake in the database, or now it's the DMV. For DMV, they also call DHS, unless they get that printout. And so if the worker's not getting a printout, that's a huge problem. They should call my office. If the worker's not getting permission to contest the TNC, huge problem, they should call my office. But the worker gets 8 days in order to contest the TNC, not 8 days to fix it, just 8 days to make contact with the federal agency. If it's not fixed in 9 days, 100 days, it doesn't matter. The employer needs to pretend like the worker cleared E-Verify in their mind. What does that mean? The employer cannot take any adverse action against them just because of the TNC. The employer needs to let them start working, needs to let them do orientation, needs to give them their shift. The employer cannot take any action against the worker just because of this TNC. Only once a worker gets a final non-confirmation is an employer allowed to fire the worker. And what we see is that sometimes final non-confirmations get issued in error. DHS is very good about fixing the issue on their end. What has to happen is when the worker calls, they click a button on the computer. SSA is less good about it, and so sometimes the worker will go to SSA, fix whatever the problem is, but the person at SSA forgets to click the button on their computer. So E-Verify thinks that the worker never went to them, and so after 8 days, the worker's time has elapsed, and they'll issue the final non-confirmation. If that happens, call my office, because we will call E-Verify with the worker, and we will get the problem fixed, being on the line to help the worker. Yes?
So who is responsible for E-verification? Is the employer or the worker?
No, the employer. And that is a great question, because there are some tools, for example, E-Verify self-check, where the worker can put their information into E-Verify and see if they'll receive a tentative non-confirmation. And some employers say, well, before I hire you, put yourself through self-check. I want to see ahead of time. Oh, that's very bad.
They give them even they print out E-Verify. Go to Social Security, cannot accept it.
So say that one more time.
They give them the E-Verify form there.
Yes?
Whatever has that page.
Yep.
Okay, we cannot accept you to work.
Yeah, no, they cannot do that.
Go and they come back after this one is done.
Yeah, that's a huge.
From feedback from Social Security office.
Right, so the question is, okay, they get the tentative non-confirmation in E-Verify, but they're told you can't come back to work until you fix this. Huge problem. Absolutely call my office. Because even if they're treating people the same, let's say they do it to everybody, still a huge problem with E-Verify. We will set them straight. And if they're treating people differently, then we would talk about opening up an investigation against the employer, because they can't be making assumptions. But this is also something that E-Verify, if you notice that an employer is doing E-Verify wrong, you can call my office, but you can also call E-Verify and you can let them know, and they'll make a friendly phone call to the employer and say, hey, we've noticed that you might be doing things wrong. And so one thing to note is that employers always have to be reasonable. And so one example is I received a hotline call from a worker who had been hired at a company, and he had given his driver's license and social security card. And the employer did something wrong. they filled out the Form I-9 on his behalf, which you're not supposed to do. Section 1 is for the worker. And so the worker didn't realize that he had in fact given his son's social security card. So the employer gets a tentative non-confirmation. And she says to the worker, here, you got the TNC, look it over, make sure that the information is correct. So far, so good, right? That's what you're supposed to do. And the worker looks at the TNC and he says, oh, my social security number is wrong. This isn't my number, this is my son's number. I named my son, he's 2 months old, and he has my same name. And I went to SSA to get his social security card. SSA tells you, sign your children's social security cards because they don't want an unsigned card out there. And so when he went to get hired, he took the wrong card out of the drawer. And they're even dated the same day, right? Because now there's dates on the social security cards. Sometimes employers think they're expiration dates. They're not expiration dates. They're the dates that they were issued, okay? And so he goes to the employer and he says, oh, I'm sorry, this was wrong. I actually, have my own number. This is the correct number. And the employer says, I'm not going to run you through E-Verify again. No way. If you wanted to name your son after yourself, you should have named him Junior. And so then the employer calls me. The worker calls me. And I speak to the employer, and the employer says the same thing. But remember, your name is a type of national origin identifier. And so that this person came from a country that doesn't use the naming convention of Junior should not work against him. And so it was unreasonable for the employer not to run him through again. Like, he had a picture of his baby. His story checked out, right? The social security cards have the same date on them. Now, if she ran him through E-Verify and he gets another tentative non-confirmation and he says, oh, my cousin is also named the same name. Here's a third card. Okay, it stops being reasonable. But employers must be reasonable and they can't make assumptions about the workers. And so this is an example of E-Verify sort of bleeding into discrimination. And, again, these are things that are often very easy for my office to fix. Now, no-match issues, they're conceptually similar as E-Verify tentative non-confirmations. And that's basically when an employer receives information that somebody's name and social security number might not match. These used to come from the Social Security Administration. Now, often they come from, for example, healthcare providers. And so if the employer receives information that somebody's name and social security number do not match, what they're supposed to do, or that the person's undocumented, or whatever the issue might be, what they're supposed to do is sit down with the worker and give them all the information and let the worker have a reasonable period of time to fix the issue. What's reasonable? Well, if the issue is that Blue Cross got their social security number mixed up, reasonable might be 3 weeks in order to be able to have Blue Cross change it in their system and fix it. If it's that the Social Security Administration issued a social security card with an incorrect number, that's actually a pretty complicated process. SSA has said that it can take up to 3 months to fix that. And so reasonable is on a sliding scale depending on the problem. But either way, employers should never make assumptions about workers just because of their potential citizenship status or national origin. And they should call my office if they have any questions, or you can call us as well. So now, how does OSC investigate? What is it that we do if we find a charge that comes in, or if a worker calls us, or if an advocate tells us what happens? There's 2 ways. First is through the charge. Somebody writes to us saying that some bad thing happened to the worker. And if it's under the law that OSC enforces, then we'll open up to investigate. So if a worker says, my employer hasn't paid any of us in the last 3 months, that's a wage issue, right? That's the Department of Labor. We would refer it to the Department of Labor. But if the employee says, my employer wouldn't hire me because I didn't get run through E-Verify correctly, or something like that, that would be a problem. You don't have to have proof. Very rarely do you ever have proof of the discriminatory treatment. But just the allegation alone, if it's under the law OSC enforces, would allow us to open up an investigation. The other option is through independent investigations. And as I mentioned before, my office me as well, have opened up investigations based on calls that we've gotten from advocates saying, hey, this sketchy thing happened to one of my clients, maybe you want to look into it, or from calls that we received on the hotline. An example is with Macy's. I received a hotline call from a worker who was being incorrectly re-verified at Macy's. Called the general manager at that store, was able to fix it, no problem. 2 weeks later, I'm randomly on hotline again, and I get another call from another worker at Macy's in a different part of the country. And I said, oh, don't worry about it. I was actually able to fix a hotline issue before. And he said, I said, let me get the number to your general manager. And he said, don't waste your breath. It's another re-verification issue. The general manager knows that I'm right, but he said it's coming from Central Human Resources. And I thought, oh my goodness, Central Human Resources. So I opened up an independent investigation because neither worker wanted to get involved formally. Macy's had no idea who had called my office, and they paid $175,000 in civil penalties, and they had to create a back pay fund of $100,000 for the workers who had been affected by this practice. And what is it that they were doing? They were re-verifying permanent resident cards, and they were not allowing people to present unrestricted Social Security cards for re-verification. They were requiring those list A documents. And so we can't stop a practice unless we know what's happening. So have your clients call us or you call us yourself. Now, what can we do if we investigate and that we find discrimination? The things that we can get for the worker are hire or rehire and back pay. If the worker suffered emotional damage because of the discrimination, it's really unfortunate, but we cannot get compensatory or punitive damages. You can under other laws. So for national origin discrimination, we had this case where this woman was working at a call center and her employer was constantly harassing her. She was Colombian, constantly harassing her based on her accent. And when she would leave the office, her employer would check her purse because according to employers, Colombians steal. And it was so bad that when this worker was on the phone and her employer was belittling her, the random person on the phone could hear her employer and said, you know what, this is terrible. Take down my name and phone number, and if you ever decide that you want to sue your employer, I will be your witness. So eventually the worker is fired. And she suffered so much emotional pain because of this. And yet all she could get, well, she didn't want rehire, that's for sure, right? So she could get front pay in lieu of rehire and then back pay for the time that she missed, but no compensatory damages for all those emotional issues. Had the employer 15 people or more, she would have been able to get those things because Title VII does cover and does allow compensatory and punitive damages. And so it depends for national origin on the size of the employer. But for citizenship status discrimination, we're the only game in town. And so there's no other law. There's one state law that covers citizenship status, but it's the same as the federal law. That's Illinois. And so there's no other way to get any sort of compensation based on employment discrimination laws. There might be other laws, like maybe, for example, it's harassment and there's a tort law underneath that state, but not under federal law. The other things that we can get are training, monitoring, meaning that the employers have to send us their I-9s every 3 months so we can look through every single one and make sure that they're doing it right. And we can get civil penalties. The civil penalties don't go to the worker, they don't go to me, they go to the Treasury. And so the civil penalties tend to be the big stick because the employers, oh, sorry, I thought I had a civil penalty. Nope, yeah, here we go. The employers pay quite a bit of money per violation. If it's citizenship status, national origin, or retaliation, the lowest amount is $375 and the highest amount is $3,200 per violation. For document abuse, the lowest amount is $110. The highest amount is $1,100 per violation. So if you're a company and you are requiring List A documents from all your non-US citizens, and you hire hundreds of non-US citizens every day, you will be paying hundreds of thousands of dollars in civil penalties. And so just to go back to this, how do you file a charge? Most important thing, it must be within 180 days of discrimination. it really is very strictly enforced. So even if the worker was scared or even if they didn't know that OSC existed, you have to file within 180 days of the discrimination. Anybody can file on behalf of the worker. You guys, the person's neighbor, best friend, doesn't matter, so long as we have cooperation of the worker. Charges can be filed in any language. And so if we have them actually not in 11, we've included a few more. We have them now in 13 or 14 languages. But if the worker speaks a language for which we don't have a charge form, they can still write it in their native language. We'll get it translated, and it'll be fine. And so really that 180 days is very important. So what resources exist? Well, as we mentioned, the hotline, right? I think I might have mentioned that once or twice. The hotline is something you can use. We also have a ton of materials. And so not only do we have this, flyer that the refugee advocate asked us to create, but we have dozens of flyers, some exactly about refugees and asylees. I have here, you see, I had a team of graphic designers, make this blue arrow to show you, to highlight to you where on the website our information is. There's, on our website, on the left-hand side, there's information for employers, there's information for workers, and that's where you will find all of the documents that we have. We also have webinars, and so this presentation in a shorter form is available every month for free. And so if you have colleagues who you think would like to know about this information, they can sign up for one of OSC's webinars, and they're live, meaning that they can ask questions in a chat function and we'll answer them. And we also have that email address. And you can take it down, it's not a problem, but we have a month to get back to you if you email us. If you call us, it's immediate. Or you can email or call me, and I'm going to give you my information as well. I will not take a month to get back to you if you email me. But just so you know. And if you want any of the printed materials that you see, we will send you for free however many you want. You want 1,000 asylee refugee flyers? Fine, we'll send them to you. It might take us a couple days to print them out, but at no cost. Any of our materials, all of our materials are free. So if you need immediate assistance, we really encourage you not to use the email, but to call the hotline Monday through Friday, 9 a.m. to 5 p.m. Eastern time. I've already showed you there. And then this is my contact information. So if you see, I put my phone number, 202-307-2246. It's in smaller font because if I don't answer, please don't leave a message. Please email me instead. Because, for example, all the refugee advocates who are calling me right now would get my voicemail. And I won't know about the problem that they need me to help them with. But if they email me, right after I finish doing this presentation, I'm going to check my email, and I'll be able to get back to them immediately. And so if you receive an out-of-office message from me, and it says that I'm on vacation, well, then you'll want to call the hotline, because it'll be several days, or weeks if I get to take a long vacation, before I get back to you. If I say that I'm out of the office for work, well, then you know that I will be checking my email, and maybe it'll just be a couple hours. So this is the end of the presentation. You've all been wonderful and you've asked great questions, but I'm wondering, is there anything else now that I'm through that I didn't cover that you have questions about?
The parolees, I just have a question about parolees is going to take too long to get their documents. Is there anything like?
So the question is about Cuban parolees, and this also applies to folks with DACA, the Deferred Action for Childhood Arrivals. There has been a delay with USCIS in getting the documents out, and I think it's because they actually changed their vendor, and so there was some delay in this process. If the worker doesn't have sufficient documents for the Form I-9, then the worker can't be hired. And so even though the worker did nothing wrong, if for a Cuban parolee, they'll have a restricted Social Security card, so they can't use that. And so if all they have is the EAD that they're waiting for, then unfortunately they're not able to get, to fulfill the Form I-9 requirements. And so there's nothing that could happen with that. But for TPS, for El Salvador, there are still 6,000 people from El Salvador who are waiting for their EADs, who've been waiting for longer than 90 days, and USCIS is affirmatively sending out each and every one of them an interim EAD. And so sometimes, depending on the office, USCIS might be more open to having interim EADs, but we've often found that usually isn't the case. But for your situation, for the Cuban parolees, you can only get a job if you're able to show a list A or B and C, and if you don't have those documents, you can't get it. No? Well, thank you very much for your participation today. Please let me know if you have any other questions. I can stick around for a little bit.